Welcome to Outside of the Box, developing a legally compliant and effective criminal history inquiry. I'm Mike Coffey. I'm president of Imperative Information Group, and I'm not a lawyer. But I am someone who has been in and around HR for my entire career, and I'm very lucky that I've worked with a lot of clients on a lot of issues across the country related to their selection process and creating what we call a bulletproof screening process. And what we mean by that when we're talking about bulletproof screening process is that, in fact, your background check is just the very last piece of your process of deciding who you want to hire. And the rest of your process has to be in place, or you're either going to end up in litigation, or you're going to make some hiring decisions that were not your best options. And so we call a bulletproof screening process as a process that looks at the entire scope of the selection process and screening process, but then only uses the background check as the very last piece of that. So we spend a lot of time at Imperative consulting with our clients about all kinds of issues, including what they ask their applicants and what they can legally ask from state to state. And so we'll spend a bit of time on that. And at some point you'll hear some of what I call the gospel according to Coffey. And I can't help it. It's my personality. I'm going to give you my opinion. You're going to get it today. But I'm also going to tell you this is what the law says. And I could make this a really boring webinar like your lawyers probably do for you, and just tell you, do this, don't ask any questions, and go away. But what we really are going to try to do is make you understand the pros and cons of some of the different approaches that are out there to complying with all these laws and still ending up, at the end of the day, compliant, but also with a safe and effective workforce, because that's our ultimate goal, right? We want to hire the right people. We want them to be productive. We want them not to pose any threats to the public or to their coworkers or to the company. We want to do it without getting sued. And there are ways to do that, and we're going to talk about a lot of those. This webinar is just one part of a 6 or 7 webinar series that covers all of these things, and we'll make reference to some of the other webinars throughout the process. And all of these webinars have been presented previously, and they are on our website, so you can go look at those and watch the previous versions of the entire webinar as well. So let's get started. Oh, well, one other thing I need to tell you is whatever I say today, it may be very different than what your lawyers have told you. And we'll talk about some of these issues, but there may be a reason your lawyer told you to do something a certain way. And so before you change any processes, we really suggest that you go back and you look at, why do we do things the way we do? Maybe there's some past history. For all you know, you're in your company entered into a consent decree with the EEOC at some point or something else. Who knows? So before you change any processes, go back and talk to your lawyers, your legal counsel, figure out why you do what you do, and then consider some of the things I suggest today. They may make sense for you in your environment. I spend a lot of time working with really good attorneys from Proxauer, Jackson Lewis, things like that, big, large national employment law firms, and some great local ones. Lynn Ross and Ganaway is a local employment law firm here in Fort Worth, where we're based, and we work with them regularly in helping their clients make sure that they're compliant. So just because you read it on the internet doesn't mean it's the rules. There's a lot of bad information on the internet about what employers can and can't ask employees, and when they can do it and all of that. But if your lawyers tell you you do it, hold off on running and changing anything. I think I've stressed that enough, but I just want to make sure you understand that. So let's start with our first poll. When do you ask your applicants about their criminal history? Just go ahead and give me a roll of response there. Okay, we'll go ahead and close that. And let me share those results with you. Okay, so you see a little over 2/3 of you, 71%, have asked about the criminal history at the point of their application. And I did look before, of the people who are registered, about 2/3 of you are based here in Texas, where we're based, and many of you are clients. Hello, we love you. But there are other we've got employers from across the country on the line too. So that's going to drive when you can ask, even down to what city you're located in. It's going to drive when you can ask different questions. So let me hide this. So, but that did say that 12% of you asked at the first interview, 12% of you asked at some other point. And unfortunately, in this case, none of you said never, which is unique. I usually come across a few employers who never ask about it. They usually start when something goes really wrong, and they wish they had known. So let's jump into why do you even care about this stuff? Why does this matter? Well, 65 million Americans have some sort of criminal history, between 65 and 70, according to the National Employment Law Project. That does not mean that employers are refusing to hire 65 or 70 million, which is about 1 in 4 employers, although some of these organizations, again, like the National Employment Law Project, would make it sound like employers just flat refuse to hire these people. We know that's not true. I spoke at HR Southwest last week 3 times. I speak to HR and SHRM chapters all over the place regularly, a couple times a month. I can tell you that it is extremely rare for me to talk to an employer who says we refuse to hire anybody with a criminal history at all, which is good because there's a law out there, or there's a Title VII decision from 1975 called Green v. Missouri Pacific that suggests that, in fact, it says, in fact, if you've got a policy as the bright line rule that says we will not hire anybody with criminal history, that, in fact, you're probably going to create a disparate impact against people in a protected class. Because African Americans are arrested, prosecuted, and convicted at a higher rate than the general population. The EEOC even claimed in one case that they lost, but they claimed that an employer's policy criminal history policy was overly broad, and it discriminated against men because men were more likely than women to get arrested, prosecuted, and convicted. They lost that case, but all the same, you don't want to have a case. You don't want to have just a bright line rule. But what you want to do, and what most employers do have, is a policy that looks at the criminal history and evaluates it, how long ago it was, what was the conduct, how long ago did it occur. So, because employers' real concern is how does past behavior predict future behavior. So, in fact, if this applicant, this was your applicant here on top, you may not want him driving the forklift in your munitions factory, right? It's pretty straightforward stuff. Their employers can use criminal records to exclude applicants where it wouldn't be the smart thing to do to put that person in that role, either because of a safety issue, which is what most of the legislators and regulators that talk about this, really focus strictly on safety. But we'll talk. There's other kinds of concern there, conduct and things, and just manageability. But this is probably not your best candidate to drive that forklift. So certainly that's one way. But then there are other ways. Let's say you have 2 candidates. You got candidate A and candidate B here, and candidate A has some sort of criminal history, and candidate B doesn't. But otherwise, they're pretty much equal. It is fair, even if candidate A's criminal history doesn't relate directly to the job, it's fair, and this is gospel according to Coffey, it's fair, but it may not be legal to consider that criminal history as part of the whole applicant. And that's what we want to do. We want to evaluate the whole applicant. If I've got candidate A and candidate B and they're similarly situated, and one of them has recent criminal history, even if it's stupid minor stuff, that may be a sign that this candidate, applicant A here, is not my best candidate. And we, just like you review people's reasons for termination, people's, candidates, education, all kinds of things. Criminal history, how they've conducted themselves in the, in their public interactions, and is probably should be fair game. Unfortunately, that's not always the case, depending on what you're operating in. So let's look at two candidates. Here's candidate A is Dick here, and Dick's got 9 years of experience. He's got an MBA. He's got neutral job references. They gave name, rank, serial number, dates of employment, that kind of stuff, but nothing good or bad about him. He performed well there in interview. Dick's a charming guy, and he had no criminal records, either in his inquiry or maybe, let's say, the background check as well. And here's Tom. Tom is really similar to Dick. They're both pretty similar guys. But now we get into Tom's situation, and Tom he's got a theft by check, an open container violation, oops, went too fast, and a failure to appear. So which one of these two candidates, when you're looking back at their conduct, is telling you, I'm going to be the guy you have to manage more? I think you would agree with me that Dick is somebody who's got a little bit more self-management, who's not going to cause quite the problems maybe that that Tom causes for you. And all things being equal, all these little petty things in Tom's background ought to give you some pause and make you really consider whether Tom's your guy or maybe you should go with Dick. Please ask questions throughout the webinar too. I will spend as much time as it takes at the end of the webinar and make sure we answer all of them. But this is the truth, right? We hire people based on their skills, the competencies, their employment experience, and all these things. But why do we fire them? We fire them for behavior. The truth is that, I've always believed, give me somebody with the right behavior sets, and I can train them for just about any job. If they've got the basic aptitude and they get it, and they want to do the job well, then I can train them for that. What you can't train, or what's much more difficult to train, is behavior. And that's really why we end up terminating most people if we've got a good process in the hiring process. And what does it cost? Obviously, it's expensive to hire the wrong person, manage them for a long period of time, and then get rid of them. It disrupts your organization. It takes management time to train them. It takes more management time and peer time to train their replacement, find their replacement, all those things. It can affect your relationships with your customers and others. So there's a lot that can go wrong, and that's why every hire matters. The downside is, of course, as we'll talk about in a minute, employers are increasingly restricted in what they can know about applicants when they make the hiring decision. We'll get into some of that. We've got a whole website called Bad Hire Days that's full of stories about applicants who didn't tell all their story, and employers who didn't know all their story, and then when things went wrong, what happened to those employers. So I'll let you go to badhiredays.com if you're interested in those kind of stories. So let's get into moving from why this information matters and why we even care about criminal history to when are you going to ask the applicant about the criminal history? 70-something% of you said you ask on the application, which in most places is still perfectly legal. But there is a national movement called Ban the Box, and the Ban the Box movement basically says that we're going to require employers, both public employers, cities and governments, and private employers sometimes, to remove the criminal history inquiry from the employment application. The idea behind that is that some employers are believed to be overly discriminating against people based on their criminal history. So if you're an employer and you're looking at a candidate and you don't know up front that this candidate has a criminal history, the proponents of Ban the Box say that, well, maybe the applicant will be so charming when you begin the interview that you will forgive them their criminal history, or that you'll find that their criminal history is not as relevant as you might have thought before you met the applicant. As a career HR guy who's worked in the selection area for a long time, That's crazy, okay? Just because the applicant is charming and good looking and suave, that should set off all kinds of red flags, really. I mean, give me that guy who's let's say I'm hiring a salesperson, give me the guy who's not so charming that I just want to throw myself at his seat. But if you're overlooking things that are truly job related, and you've got a criminal history policy, which we'll talk about in our next webinar on how to develop a criminal history tool that helps you know what criminal offenses are really relevant. If you've got all these policies in place, how charming this guy is should not play into the decision if based on that history, that guy's just not a good fit. If he's a high-risk candidate, you should know that as an employer up front. I would also argue that, again, like we said earlier, if I've got multiple candidates and I'm trying to figure out of these 20 candidates who are the 3 I want to interview, I ought to be able to have a full picture of each of these candidates' history, where they've worked and where they went to school and what kind of positions they've had and whether they've created any criminal offenses that are either relevant to the job or so numerous that they give me some pause about this person's behavior. But the ban the box movement says that, well, we are discriminating against people with criminal offenses, and even though under federal law and most state laws it doesn't put you in a protected class to be a former criminal offender, it does, they still are trying to create protections for those folks. So let's get into some of the ban the box samples. This is a sampling of the state and even local ban the box rules across the country. You see in San Francisco, California, employers cannot ask until after an interview has been conducted. So they can't even know about somebody's criminal history until after the interview. So that, depending on the position, that can be that can drag out quite a while. In fact, San Francisco's got a number of weird ordinances or rules in their ordinances. They you can't consider minor infractions like traffic tickets when hiring somebody in San Francisco, even if they're a driver. There's no way you can consider that, which is kind of nuts, right? We've got a client that operates a golf course in San Francisco, and they always, across the country, use driving records to determine if this person is somebody they want driving a those large industrial mowers on their golf course. But in San Francisco, they cannot ask, they can't look at driving records or inquire about people's their infractions. If it's not a misdemeanor or felony in San Francisco, and California has these unique things called infractions, which aren't criminal offenses, like speeding and reckless driving, then an employer in San Francisco can't consider that. So then you see, like Washington, D.C., you can only inquire about an individual's criminal history after you have made an offer. So we're getting really late in the hiring decision, right? At this point, we're looking at, we've maybe, depending on the position, we may have spent 2 weeks on this candidate, 3 weeks on this candidate. Maybe our second or third best candidate has already found another position, especially when we're looking at, 4 or 5% unemployment. And we get down the road and we find out, in fact, this part, we make an offer and we ask the individual about their criminal history at that point, and it comes back, or we run the background check, and it comes back, and in fact, he has a criminal record that is high risk enough related to the job, and we're looking at those factors. Again, we've got a whole policy on that, and I'll do the whole webinar on that in a few weeks, but we've got a policy that looks at those green factors, the age of the offense, the relationship to the job, and the nature of the offense. We look at all those things, and we say, okay, I just can't put somebody with a sex offense working with Alzheimer's patients, for instance. Or I can't have somebody who was convicted of car theft working as a salesman on my car lot if it was, because of this recent car theft conviction. There are a whole bunch of those. Or you just see a pattern of bad behavior that doesn't tie directly to that offense, although some of these ordinances that are up here, when you read in the ordinances, they require strict relationships. So somebody could have robbed a bank 2 years ago, but if they were just applying to work in your organization as, say, a forklift driver, you would be not in some of these ordinances are written, you wouldn't be allowed to even consider that offense related, because it was not directly related to the job. So you can see that we are definitely in an environment where it can be difficult to for an employer to make the best decision available, because either they can't have the information or they cannot use it once they have it. So you see these, you see all of these. These are the states that the states and municipalities that currently have banned the box, and ban the box is really taking off at the local level. Here in Texas, Austin, Texas is looking at it and will probably pass it. They've already passed it for public employers, for the local government. Local government has taken the criminal history off the employment application, and now they're debating it in Austin about adding it to to private employers operating in the city as well. So you will see a lot more of these, which is going to get difficult for employers who are operating in multiple jurisdictions. How do you do this? If you've got a sales office in San Francisco and one in Texas, say in Dallas or Fort Worth, here where we are, and maybe one in Maine, what are you going to do? If you've got 3 different sets of rules, how are you going to do that? Often your employment law attorneys will tell you that you want to, the easiest route is to go to the lowest common denominator, which probably means a state like Massachusetts or New York now has New York State and New York City both have specific requirements for employers, so that you can end up with the lowest common denominator, even if it's only a small part of your employee population. And the real question there is, does that make sense for you as an employer doing that? So you're missing a lot of information from a lot that you can legally use in other jurisdictions, just so that you have a one-stop approach to all your criminal history inquiries across the country. We're recommending our clients not do that, although we recognize it, especially if you don't have a pretty sophisticated ATS system, it can be kind of hard to know what jurisdictions are really going to be relevant. And so you've got to look at, how do we know this? Or maybe we're just going to look at the law where that particular job is posted, and that's one way to do it. Is okay, where that position is at, and that's what a number of employers are doing. They're saying, okay, well, we're in Texas, and this position's in Texas. Even though we have operations in California, and we have operations in Colorado, and we have operations in all these other places, we're just going to follow where the position's located. So for a position in Texas, we're going to follow this rule. However, for a position, regardless of where the applicant's from, for a position located in Massachusetts, we're going to follow the Massachusetts law for those candidates. And then you might say, and that's what we generally recommend our clients do, but there are some employment law attorneys out there who are advising their clients also look at where the applicant lives. So the applicant lives in, let's say, New York City, and he's applying for a job here in Texas, which has no real ban-the-box rules. Maybe you shouldn't inquire into the criminal history of a New York City resident until after you've made an offer, in order to comply with New York's law, even though your position is here in Texas. I think that's overkill, and but again, always do what your lawyers tell you. You might argue with them. I argue with mine a lot, and usually, either I come around to their position or they come around to mine. But you've got to be willing to really figure out what the law is, what the requirements are, what's the case law, and what are my risks. And let's get into, beyond when to ask, which is the ban-the-box issue, let's also get into what to ask. And we're going to spend a good bit of time on the criminal history inquiry itself, because it's getting really convoluted out there, what you can and can't ask. The most important thing I can tell you is where, as much as possible, your concern should be the underlying conduct. So regardless if let's start with misdemeanors and felonies. Regardless of whether the offense is a misdemeanor or felony, that shouldn't matter unless there's some state or local ordinance that otherwise applies. What should really matter is how does the conduct that this person engaged in affect their fitness for this position. So if somebody has multiple convictions for shoplifting, they're probably not the best employee. If those convictions are fairly recent, they're probably not the best candidate for employment in your retail environment. Okay, it just makes sense. If somebody with sticky fingers, I'm not going to put them in handling cash. I'm not going to put them in where they've got access to easily removable merchandise, things like that. And the underlying conduct is what you really care about. For instance, there's a statutory rape. Having sexual intercourse with somebody underage is a felony in most states. In Louisiana, you can have a misdemeanor version of statutory rape. So if you're hiring somebody to work in your summer camp, catering high school kids, and you only ask about felonies, you may not find out about their statutory rape conviction. And those are the kind of things that you have to understand. So misdemeanor, felony, you'll know, but they are not your primary concern. Your primary concern, and even the EEOC says this, should be, is it reasonable to believe that person engaged in the underlying conduct? And if it is, how does that affect their fitness for this position? Another issue that comes up is whether the position was, what the outcome of the case was. Was it a dismissed case, or was it a conviction, or was it something in between? This is not a black and white issue, even though we hear it all the time from a lot of people who don't deal with this regularly. Conviction means, yeah, they did it. They've been found guilty by a court, either because they pled guilty or no contest, or they were found guilty by the judge or a jury. That's guilty. That's a conviction. But and then there's the other end where somebody's found actually innocent, or they're found not guilty by a judge or a jury. That's the other extreme. May not be reasonable to believe they engaged in the underlying conduct if they were truly found not guilty. It may be, though, in some cases as well. You would have to really dig into the underlying conduct. But there's a whole gray area in between these. There are all kinds of cases like deferred adjudication. In Texas and most other states, you can, for many offenses, especially if you're a first-time offender, you can apply for a deferred adjudication. You can make it, do a plea deal and get a deferred adjudication for many offenses. And deferred adjudication means you plead guilty or no contest to the offense. So you say, yeah, I did it, or I'll plead guilty to it. But rather than enter that guilt against you, the court can sentence you to probation. And sometimes the probation is just don't get in trouble for 3 years or 90 days even. But sometimes the probation is attend anger management class. Sometimes the probation includes, doing community service, picking up, trash on the weekends alongside the road, all kinds of things. Doing regular drug tests, all kinds of things. So that's a deferred adjudication. And at the end, when you complete the probation, deferred adjudication can be dismissed. And so just because the case was dismissed, is it reasonable for the employer to believe that the person engaged in that underlying conduct? Yeah, probably is, right? They pled guilty or no contest, and I would argue, and our advice to our clients, except where it's not legal under state law, is to consider deferred adjudication and pretrial diversions and other programs like that, just like they consider a conviction, that the person engaged in that conduct, and so let's view that conduct and figure out how that relates to this position. Another issue that comes up is what are we going to do, and we talked about this a minute ago, but when we're talking about what we're going to ask, when we're talking about ban the box, we're talking about when we're going to ask in different state laws. But you also have state by state and even city by city, you have specific requirements about what you can ask an applicant, what an employer can consider or what they can ask. And so what are we going to do in those cases? Again, it goes back to the same thing. Like we talked about with ban the box, are we going to only ask criminal history questions after we've made an offer 100% of the time across the country? Or are we, in the case of the criminal history inquiry, what are we going to what are we going to ask? In California, I can't ask about certain marijuana convictions. You can see there's different states here. This is our sample criminal history inquiry, and you can see it's got carve-outs down here, and we'll talk about some of these: California, Connecticut, Georgia, Massachusetts, Michigan, New York. There's a variety of them, so you'll see we'll talk about some of the specifics here later. But it may be that it makes sense for you to have an inquiry that has all these carve-outs so that you get as much information from your applicants nationwide as you can, but still tells applicants, in California, please exclude misdemeanor convictions for offenses involving 28.5 grams or less of marijuana. So, we would be concerned about that in some jurisdictions, maybe, especially if you're a pharmacy or something. But in California, we can't ask about that. And so, you may have these carve-outs so your applicant knows, or you may have a unique criminal history inquiry just for your applicants in a particular state. Like this is our sample criminal history inquiry, and we'll go into some of the contents of that in a second. But basically it becomes a two-page document when we do the multi-state across-the-board inquiry because of all the carve-outs. But our Texas-only inquiry all fits on one page because Texas is a state, like most states, that has no specific requirements or limitations on what an employer can ask. The important thing to remember is when you get the information, you don't want any bright line rules. You want to get a lot of good information, but then you want to have a policy backing that information up that says, here's how we will use that. I like my criminal history inquiry document because it's a separate document. Even if you're going to ask at the employment, on the employment application, you can still have this separate document that goes in the employment application. Then when the applicants responded, you can separate that information out from the rest of the employment application, because your hiring managers, if you've got a good policy in place, your hiring managers most of the time will not need to know about somebody's criminal history. They won't need to know about low-risk stuff that has no relevance to the job, and they may not even need to know about medium-risk stuff if your HR policy says, here's how we evaluate things that we classify as medium risk, and in this case, this person is fully eligible for hire. We're not concerned about it. The hiring manager may not even need to know that. Now, if it's a high risk and it's not something that you have an absolute no hire policy, for instance, a sex offender working with children or vulnerable populations, we're not going to put anybody in that role, period. HR, you see that, you're not going to share that with the hiring manager, but you may have some others where you've got a really qualified candidate, but he's got something that shows as high risk because of the nature of the offense. You may want to get more information from it, and you may want to sit down and talk to that hiring manager about it. Perfectly legit to do that, but I just don't think you want somebody's criminal history floating around, especially when it's not directly relevant to the job, because let's face it, you do have some, or if you don't now, you have had in the past, some knucklehead hiring managers who think they've got some special insight into human character, and the law be damned, and I'm going to do whatever I think's best, and they just, they're going to say, well, this guy has got this offense, and I knew a guy once who had that kind of offense, and he's just not reliable. Even though the offense was 20 years ago, they're saying, his guy got convicted of shoplifting 20 years ago, he's a thief, we don't hire thieves, period. Well, and it's probably, first of all, it could get you in trouble legally under Title VII claim. But beyond that, it's just dumb. And do we really want to eliminate qualified candidates, especially with 4 or 5% unemployment? Do we want to make it harder for ourselves, for our company to hire really qualified candidates because of something they did that's not relevant to the job and is so far distant in the past to not be reflective of who they are today? So I like having the criminal history question completely separate from the application so that you can separate it and not have it move around the organization with the application. That's, again, gospel according to Coffey stuff, but I think it's a good idea. So this is, again, the criminal history. You do not want this question, and I'll give you a second to read it. This is not the question you want on your employment application. This would be a bright line rule. It says if you got any history, we're not going to do it. I mentioned Green versus Missouri Pacific earlier. That's the case from 1975. Missouri Pacific Railroad had a policy that said if you have any criminal history at all, you're not eligible for hire, period. Well, Mr. Green was a African American, and he had been a Vietnam War protester. He had refused to register for the draft, and he went to federal prison for it. This was a man who was following his convictions. He spent, I think, a year, 18 months, something like that, in prison, and was out, was released, then applied for work at Missouri Pacific. The only thing he had in his criminal history was that one federal prison case where, for refusing to register for the draft. Missouri Pacific said, sorry, but our policy is that we don't hire anybody with any criminal history, period, so you're not eligible for hire. Mr. Green sued under Title VII, claiming that this is creating a disparate impact on minorities because they're arrested, prosecuted, and convicted at a higher rate, and because there's no business justification for this policy, it's overly broad, they're creating a disparate impact. And his argument on the Duke Power case from 1971, which set out that idea of disparate impact, he was really the first to use it in the context of criminal records. And so you don't want this policy. This is a bad policy. So let's talk about what you ought to have in your criminal history policy. Now, let me also tell you, I should have said it up front, that you're going to get all of the slides, and the slides are mostly pictures, but you're going to also get all the notes pages. For every slide, there's notes here, including the text of information that we suggest you have on the employment application stuff. Otherwise, it's going to be the slide after slide of text, which would be really boring. So we're going to, everybody who's registered for the webinar will get a link probably tomorrow morning with the HRCI information. Take a survey for us, telling me how I did, and you'll get the HRCI information and a link to download the slide notes so that you'll have everything. So when we're looking at our criminal history inquiry document, we start out with a note telling the applicants that, hey, if you provide false information or incomplete information, if you're not responsive to our inquiries, then that's a bar to employment. If you lie to us, and I tell this to employers all the time, whether it's reason for termination or your criminal history inquiry or whatever else, if you see an applicant being evasive, that should be a big red flag to you that, you know what, we're asking a legal question here, and we expect an honest answer. We don't expect answers, questions to be skipped. And what we really don't want is will discuss, because no, we won't. Because will discuss is the applicant self-identifying to you that he's going to be a problem, that he's going to decide which of your policies apply to him and not. I would always tell an employer, will decide is a red flag. Now, here's the other thing. Unfortunately, groups that work with former offenders often tell those former offenders that that's what they should put on the application, will discuss. And I speak from time to time to the local group that helps former offenders find meaningful work, and it's a very important thing in our society. We've got to do. We've got to find ways for people to be successful outside of prison. But that, just because there's a job out there available to them doesn't mean that they're right for the job because of their past conduct in every situation. So all that to say is, let's start by just telling our applicants, hey, we want you to answer everything. The language we suggest is failure to answer the criminal history question accurately and fully may be considered fraud and result in the elimination of your consideration for this position or your termination from employment. The company conducts thorough background checks. So tell them up front, hey, we're going to check what you say. We're probably going to catch it even though we're asking you now. So tell us the truth up front. Just, it's easier for everybody. And then you should also have that comment in there that we're not going to use this information in violation of any equal employment opportunity laws. We're going to evaluate all of your submission, including the criminal history. And just because you've had some past interaction with the judicial system does not mean that you're going to be eliminated from employment. We're going to look at the information that you provide and its relationship to the job. That tells the applicant right up front, here's what's coming up. Then we say, well, before you even get to the criminal history, one thing many employers fail to ask is, ask about sanctions, whether it's Medicare, Medicaid fraud, or some sort of financial services fraud that they've been engaged in, or they've been sanctioned by some government entity at the state or local level. A lot of times that stuff doesn't result in criminal prosecution, but somebody may lose their license, or they end up on a list of prohibited parties from participating in federal government programs. Why not ask, why wait till later in the employment process to find this out? Why not ask right up front on the application, so that you know right up front if you're going to wait? You know, if you're a federal government contractor and say you're taking Medicare or Medicaid money from a state or federal government, you're prohibited in many cases from using people who are listed on, from whether they're employees or contractors, that are listed on these lists of people who've been sanctioned and are excluded from federal health care programs. If that's the case, why don't you ask the applicants right up front rather than waiting for the background check to hopefully reveal that? So we always start, whether it's, you know, we cover healthcare, financial, and government procurement programs. So it's a great way right up front to ask them that. And if you require specific licensure for the position that you're considering this person for, you ought to have something on your application to ask about that too. Have you ever had your license revoked or suspended, or been denied a license? And give us the details of that. And then you can go get the additional information from whatever regulatory body that is. But at least, and maybe it was 10 years ago and you don't really care anymore, but have the applicant tell you, and then you can decide if it's relevant. It's not the applicant's job to decide what's relevant, it's yours. And then when we get into the criminal history question, we tell them, show us everything, okay? To the extent allowable by law. And again, I mean, you'll remember I mentioned, you know, all these states and even municipalities have their own little local rules now about what you can and can't ask or consider. But get as much, you want as much information from the applicant as possible. If you've got a policy that will guide your use of that information in a fair and reasonable manner. And again, that's why I don't think you want your hiring manager to have all this information. So let's look at what that question, it's not even really a question, it's more of a, it's just a request that they list this information. So, and now we're getting into a lot of text, I'm sorry, but just to cover it all. Please list all misdemeanor and felony matters, okay? Again, we talked about misdemeanor, the difference between misdemeanor and felony. You don't care, you care about the underlying conduct. I may be less concerned about a 5-year-old felony than I am a 2-year-old misdemeanor, depending on what the conduct was. A felony conviction, you know, somebody may have a felony conviction 10 years ago for driving while intoxicated. In Texas, in many states, your third DWI is a felony. But do you really care about that for somebody who's going to be driving a desk in your office? Probably not. If all they do is, you know, sit at a desk all day and never drive in the course of their job, you probably don't care about that, even a 5-year-old DWI, even if it is a felony. But you may care about a 2-year-old misdemeanor theft case, or a 2-year-old misdemeanor assault case, or a 1-year-old misdemeanor assault case. If somebody got into a fight and they punched somebody out, this may not be the guy you want working the customer service desk at Target on the day after Christmas, right? So it makes some sense to, you know, let's not be concerned about misdemeanor and felony, and certainly let's not let the applicant decide. Let's have the applicant tell us all of it, and then regardless of age, again, you get to decide as the employer what's relevant within, you know, the state and local rules that apply to you. You get to decide whether something's relevant, whether it's a 7-year criminal offense or a 10-year-old criminal offense. It could be a 20-year-old criminal offense. Somebody was convicted of murder 20 years ago, and they've spent 15 of the last 20 years in prison because of it. I want to know that as the prospective employer, but, you know, because I'm going to evaluate them against everybody else. And you know, it may be that somebody who's only who's been out of prison 5 years looks like a wonderful candidate because they present all this information and they show what they've done in the ensuing 5 years. Maybe they can demonstrate things that happened in prison, that classes they took, things like that. We had a client call us a few weeks ago and say, hey, this guy got a, you know, normally we wouldn't hire somebody with this offense, but while he was in prison, he got an undergraduate degree. He's been out for 3 years and he just finished his master's. And he's worked full time the whole time he's been out at a very, you know, pretty blue-collar job, but he's got his master's degree now, and we want to hire him. He's going to be older than most of the people he's working with at that entry-level position, but we're really interested in hiring him. Are we crazy? And the client sent me everything they had about him, and we talked about it for a good 20 or 30 minutes. And ultimately, we both agreed, this is probably a great candidate. There's no reason not to hire this person. They've demonstrated that they're somebody who who's a different person than who they were when they committed the offense that took them into prison. I've had clients who've done that and have regretted it later too, to be honest. We had a client who hired someone who had a great story like that, and within about 3 years, he had embezzled several $100,000 from them. It can happen, but as employers, we act with imperfect information. We can't read people's minds. We can't always know their intent. All we can do is take the information that's available to us and make the best decisions of, that we can with what we have. So all that to say, you want the information regardless of age. And then, depending on, there are some states that have limitations on how far back, what you can even consider. And so you want to follow those rules. And you want the information regardless of outcome. Just because it was dismissed does not mean you don't care about it. And as an employer, so, let's find out why it was dismissed. Let's get the applicant to tell us everything, not just convictions. And then we will look at the details and make the decision. You may say, oh, this was dismissed and it was 10 years ago. I'm not concerned about it. But you may see some offense that was dismissed 5 years ago or 8 years ago, and you want, oh, well, that's a red flag. We want to understand what happened. And it may be when you investigate into it, the underlying conduct didn't constitute a criminal offense that was prosecutable or convictable, but there's enough information to demonstrate that that underlying conduct is enough that we don't want to hire the person. They may not be convicted technically of the crime, but there's enough information to say that they engaged in this offense that they couldn't technically get a conviction, but we know the underlying conduct now. So you want all that to say, where it's legal, get as much information as you can, then you can make the decision. And certainly you want to make sure that they're giving you active cases too. Because if somebody's had a case filed against them and they're going through the system, it's a good thing for you to know that. And in almost every state, it's perfectly legitimate for you to consider that and make a hiring decision based on it. And I know a lot of clients who say, if they've got a policy that says if the pending case could result in that person's incarceration and unavailability for work, we tell them they're not eligible for hire until after that case has been resolved, and then they can come back and reapply if we have a position available for them. But we don't want to put the investment into hiring somebody who's not going to be able to always, be available to work for the next, 6 months or a year at least. We want a return on an investment before, they go to the Gray Bar Hotel or whatever. And we want all this information for any case in which they were charged. In other words, if a case was filed against them, we're not talking about just arrests here. We're talking about cases actually being filed. So they went before, in almost every jurisdiction, you go before some sort of judge, a magistrate judge or somebody like that, who says, yeah, there's probable cause for this case to proceed and for the DA to file this case. And so we want to know everything for which you've been charged, regardless, again, of outcome. So it's not saying for which you were convicted. We're saying for which you were charged if there was a case filed against you. Or if you participated in a pretrial diversion or some other program to avoid prosecution, because there are cases like that where you get arrested and then the DA, the district attorney or the state prosecutor, whatever it's called in your state, offers you the ability to plead guilty, enter a plea of guilt or no contest, sign basically an admission document. And then they say, okay, and you go to anger management classes. This is kind of a first-time offender program. We won't even file the criminal case against you if you jump through all these hoops. You screw it up, though, we're going to take this admission you signed, we're going to file the case, and we're going to present that to the court. And that would be bad for you. So it's a great opportunity for first-time offenders not to end up with a permanent criminal record. But that doesn't mean that if they participated in a pretrial diversion program a year ago, but they're the best candidate for you in your role, depending on what the underlying conduct was. Then, after you've asked that question, we also want to tell them, tell us about any sex offender registration, because sometimes there may be a state law that says you can't, as an employer, consider a criminal offense more than 7 years. There are states like that, regardless of the offense even. 10 years in Massachusetts for a felony, so let's say. But you may find that somebody had a conviction 10 years ago for some offense, and then for some sex offense, but it's been more than 10 years, and you can't legally use that, consider that information, or even ask about it. But you may see that, you know what, they're registered sex offenders, and that's all I need to know. Somebody who's a registered sex offender in a certain environment, they're never going to be a good fit. I just dealt with a client yesterday, in the last couple of days, working on an issue that they've got a candidate whose criminal history, they didn't ask a good criminal history question, but he apparently lied on his criminal history question too, but he said he didn't have any history. And the background check came back clear as well, and this is actually a prospective client, and the candidate actually is a current employee, in fact. And so their background check came back clear, and but then they found out later that he was a registered sex offender, and that wasn't included in their background check. And so their lawyer called me and said, "Hey, how can that happen?" I said, "Well, a lot of different ways," but the lawyer gave me the person's information, and I saw, yeah, his criminal case was a sex offense against a child, and he got deferred adjudication for it, and he served 7 years deferred adjudication for sexual assault of a child. That's a bad offense. It was a 13-year-old girl, I believe, and so that happened, but he got deferred. So when he completed the probation, the case was dismissed. However, and that dismissal was more than 7 years ago, so we couldn't even tell the client, the employer, about it, because of the Fair Credit Reporting Act doesn't let us report dismissals of more than 7 years. The employer could certainly ask about it in this context because of the state they're in, but the sex offender registry would have pointed to the employer that, hey, there's something else here. So if somebody's actively registered as a sex offender, you've got other questions to ask. And so you might as well ask on the criminal history inquiry, even if they say they don't have any criminal history, you should ask, are you actively, do you have any obligation to be registered as a sex offender? Or for violent offenses, there are a few states that have violent offender registries, and you may want to know, even if you can't find that case or whatever, are you required to register? And that's the kind of thing you might want to know. And then you want to ask about recent arrests. In the last year or 18 months, have you had any arrests? And we're talking about arrests, not cases filed in the judicial system. Or arrest, that means you're dealing with the police agency, law enforcement. Tell us in the last 12 months, 18 months, something like that. Because, and tell us if there are charges pending or if there's an ongoing investigation. Tell us what's going on with it. Because what you don't want is the person coming to work for you, then, often somebody may get arrested, put on bail, and the case continues to be investigated for whatever reason, and they may not have a case filed against them for 6 months or a year. So you don't want to find out later that this person's been suspected of engaging in this conduct for all this time. Now, just because it's an arrest doesn't mean that they're guilty of that offense or that they engage in the underlying conduct. But then you can have a conversation with the applicant about the details of that. And I've got a whole webinar just on what to do when an employee gets arrested. I gave that presentation last week at HR Southwest, in fact. But you want to ask those kind of questions so that you can, this question about arrest, recent arrest, very recent arrest, so that you can dig into that even more and understand what happened, and maybe get additional information. Your background screening company might be able to go get copies of arrest records and arrest reports, things like that, so that they know what really happened. Or you can ask your applicant to go get copies of the information the police have collected about them. Now, their lawyer is going to tell them not to do that probably, and then you've got another decision to make. And I would say you want to make those decisions and working with your legal counsel. And if you have questions, always feel free to give us a call. The other thing we suggest employers do is tell their applicants, I think my PowerPoint just crashed. I'm sorry about that. We'll see if it survives or not. But it didn't. So let me see here. Let me pull my PowerPoint back up. Don't you love computers? So what you might do is, I don't even remember what the slide was. We talked about criminal arrests, and let me pull this up here. Oh, we're having fun now. There we go. Oh, yeah, that's right, expunctions. If you may find that, I hope everybody can see my screen. Let me confirm that. Audience view, yeah, good. So you may find that the applicant does have something. Well, actually, you won't find it out, but let's say the applicant does have a case that's been expunged. And an expungement means, as far as the law is concerned, it never happened. That conviction never happened. And in fact, when they expunge a case, you can go in with usually you can go in with the file number or the case number and walk into the courthouse, and they can't lay their hands on the record because it's been actually destroyed. Then there's another. That's the most serious kind of expunction, where it just no longer exists. But then you may have a case that's just sealed, or for some other reason the court has designated that it's not available to the public. Many states have laws on the books that say an employer can inquire about or consider sealed or expunged cases. And so we do recommend our clients just go ahead and exclude expunctions from the mix, because quite honestly, even if the applicant told you something about it, you wouldn't have any way to verify it because you can't get your hands on that information. And a court has decided at this point that this is really not information that the public should have about this individual. And at that point, I think as an employer, you're pretty safe saying, okay, when a judge has said that, then under the laws of whatever state that is, we're probably safe making that, making a decision. So we don't want expungement, sealed cases or whatever. And then you just want to simply have the applicant give you the details of the case. And we do two things here. Get the details, and you have them give the date, the jurisdiction, where it happened, so you can go find it, or your background screening company can go find it. The offense information, what they were charged with, and then the outcome, the status, maybe it's a pending case, or maybe it's a disposition, it has a disposition, it was dismissed, or it's convicted, or whatever, and what their sentence was. Have them provide that information. And then you can always, I really recommend you always feed that back to your background screening partner to make sure that they go verify that, because that offense could have been in a jurisdiction where the person didn't live, and there's no reason for your background screening company to go check those live records in those counties where this offense happened. And so always feed that back to your background screening company so they can go verify it for you. And then to keep the EEOC happy, we're including in our sample language an individualized assessment section. And again, I've got a whole webinar out there on our website just about EEOC issues, and I would recommend you go read that. But the EEOC basically believes that an employer should give an applicant a reason to explain, opportunity to explain why your policy should not apply to them with regard to criminal history. So what that might look like is, in fact, maybe they've been out of jail for 5 years and they've completed a college degree and they've done some other stuff, or perhaps they can tell some compelling story about how they're, what they learned from that. Whatever it is, give them an opportunity to do that, because the idea behind the EEOC's belief that you should do an individualized assessment is so that you're really considering more than just the black and white fact of the offense. You're looking at the whole applicant and everything that they have. So include it right here. That's certainly much better than after you find out the guy's a murderer or a rapist or whatever, that you want, that you call them into the office and sit down with them to have that conversation. I'd say just include it here so you've got proof. And again, we get an individualized assessment in our background screening policy considerations webinar, so you want to probably go look at that if you're dealing with that kind of issue. But this is just a recommendation we make. Then we could go through, if we had a lot of time, all the state-specific concerns that relate to what you can ask. And when I send you the slides, you'll have a few notes about on each one of these states. More out there. It's ever growing. But we do have all of these webinars available on our website. They've all been previously provided, and they're all recorded out there, so you can go look at them. And every presentation changes. We do these presentations twice, each of these presentations twice a year, and it changes every time. So I would recommend that if it's a topic that's of interest, it's likely that the information around it may have changed in the last 6 months or a year. So go look at when we're offering it next and register for that. And now we'll go to questions, and I will stick around as long as we can. Right now I only have one question, but if anybody has any additional, please go ahead and ask them. We typically hire in Texas, Florida, and Oklahoma, but we do have remote positions where anyone, anywhere could apply. We ask criminal history during the application process. Are we violating any laws if someone from a state city with stricter laws applies to one of our positions? Okay, thanks, Terry. Well, it kind of depends. If it's really a remote position and that person is going to be working from home, say, or maybe they're a sales rep, so all you're based in Texas, but you've got sales reps all over the country, then yeah, you need to follow the rules in the jurisdiction where that person's going to be working. If that's their primary place of employment, you're probably following the employment laws in that state. You're probably following the payroll laws and making tax payments and all that. That's a good sign that, yeah, you ought to follow the laws where that person's going to be working. That can be a struggle. Hopefully you've got a good ATS that's pretty programmable, so once that kind of position, the applicant puts in their address and it says, okay, this position, we're always going to consider that they're going to be working in the state where they're applying, so we're going to ask our criminal history questions this way for that person, which is probably good. And quite honestly, even beyond the criminal history question, you've probably got some other considerations at some point in the hiring process that you need to look at, including taxes and reporting of new hires and things like that. So, just treat criminal history inquiries and your use of criminal history in general just like you would all the other laws relating to that person's employment. Oh, okay. Terry followed up that the work can just be done from home. That's fine. If their home is in that state, then they're your employee in that state. And like I said, you've got all the, you should probably be paying taxes to that employee based on that state's laws. Not paying taxes, but collecting taxes and making unemployment payments in that state and all of that other stuff as well. If they're your employee and they're based in that state, even if they are working, especially if they're working from home, if their home's in that state, that's where they're based. I would say follow this rule as well for that state. Any other questions? Right now we don't have any. Do feel free to send me any emails with questions about that you may have about your particular situation. Otherwise, just to remind you what the process is, we will send you an email probably later this afternoon, but it may be as late as tomorrow morning, thanking you for attending and asking you to complete a survey telling me how I did. And I hope you'll forgive the technical crash. That was Microsoft's fault, not mine. But then we will, if you'll do the survey, give me that feedback, then we will, following that, give you, after you complete the survey, it'll take you to a page with all the HRCI and SHRM PDC information for your recertification purposes. And it will also have a link to download the slides from this presentation and all the notes that come with the presentation. And so I appreciate everybody sticking. Oh, I got a question. Okay, let me answer this real quick. What criminal record question can be asked by a consumer reporting agency? Okay, if you're a consumer reporting agency, that means you're the background screening company. Your background check company can only ask the applicant the same questions that you can ask them. In fact, the Fair Credit Reporting Act says that a background screening company cannot make any inquiries that would be illegal for the employer to make. So it's the exact same thing. So your background screening company should only be asking the question that you can legally ask. And we work with our clients to do that. That's a big part of the service we provide, making sure that any conversation we have with their applicants or their, we make sure that everything we do is legal, not only from the point of view of what I can do as the background screening company, but also what we can give what our employers can use. We internally have a policy that we're not going to give, even if we can legally report information to an employer, and there are a number of cases where we can tell an employer something that they can't legally use, we're not going to give them the rope to hang themselves with. So we wouldn't ask, we wouldn't collect that, provide that information to an employer if it's not something they can legally use. And I guess that's on the way out. That's what we do. We're an employment background screening company. In that whole background screening process, we're the very end of that process. What I would suggest is that we want to work with clients who will work with us, and we want to help you get your whole screening process in place so that ideally all the background check is at the end is a lie detector test. Did the person tell you the truth or not? And the only time somebody should fail the background is when they really lied to you. And we work with our clients to make sure that you're legal, that you're compliant, and that you get the best information available. You might have seen that some of the background screening companies, some of the big guys in our industry just entered into like a $13 million settlement with the Consumer Financial Protection Bureau. That happens a lot in our industry. There are tons of cases out there against employers, or against background check companies and employers for not following the Fair Credit Reporting Act and just not making sure their information is accurate. We don't have that issue. I mean, I've got clients on the line, and I can freely say we just rarely, I mean, we've changed 3 reports in 5 years. We rarely make a mistake. We're more expensive than your $30 background check over the internet too, but we can give you a really good report typically in about 3 business days that you can really rely on, and you can take it to the bank. So your hiring decision based on that final background check is bulletproof, just like we want your whole process to be bulletproof. So if that's the kind of company you want to work with and you're not working with us now, we would love to have you give us a call. That's how I pay for my kids' orthodontia, but also we just love working with clients who want to get it right and want to do it right. So if that's you, please call us. If you have questions, please call us or send me an email. If I can be of any assistance, I'd be glad to. Thank you very much for joining us for the webinar today.